A gun trust is a legal entity created under state trust law, specifically designed to acquire, hold, manage, and transfer firearms, particularly those regulated by the National Firearms Act, NFA, of 1934. It can be revocable, can be amended or revoked during the settler's lifetime, or irrevocable, cannot be changed once established, often used for asset protection or tax planning. Types of firearms in a gun trust. Gun trusts are often used to manage firearms regulated by federal law, especially short-barreled rifles, SBRs, rifles with barrels shorter than 16 inches, short-barreled shotguns, SBSs, shotguns with barrels shorter than 18 inches, silencers, suppressors, devices designed to reduce the noise of a gunshot. Machine guns, fully automatic weapons manufactured before May 19, 1986. Destructive devices, explosives, grenades, and other specialty firearms. These firearms are classified as Title II weapons under the NFA, unlike most conventional firearms, which are Title I firearms under the Gun Control Act of 1968. Why is a gun trust necessary? 1. NFA compliance and registration. Under 26 U.S.C. paragraph 5861, it is a federal felony to possess an NFA weapon that is not properly registered to you in the National Firearms Registration and Transfer Record, NFRTR, maintained by the Bureau of Alcohol, Tobacco, Firearms and Explosives, ATF. When an individual buys an NFA item, they must file ATF, Form 4, Transfer Form, or Form 1, Manufacture Form, submit fingerprints, photographs, and CLEO notification, pay the $200 tax stamp or $5 in certain cases. Wait several months for approval. With a gun trust, the trust, not an individual, is the legal owner. All responsible persons named in the trust must comply with background and fingerprint requirements, post Rule 41F. But multiple people can lawfully possess and use the item. Trustees can be added or removed easily. It simplifies estate planning and transfer of ownership. 2. Avoiding constructive possession, legal liability. Constructive possession occurs when a person has access or control over a restricted item, even if it is not physically on them. For example, if a spouse or roommate knows the combination to a safe containing an unregistered NFA item, they may be criminally liable under the theory of constructive possession. Under U.S. v. Turnbow, 1999, U.S. AP Lexus 2458, 8th Sursar, constructive possession of a firearm existed even without physical possession when there was joint access and control. A properly drafted gun trust eliminates this risk by naming only authorized individuals as co-trustees or beneficiaries with limited access, ensuring all users are legally covered. 3. Multi-person use and family protection. Unlike individual ownership, which limits access to the registered individual, a gun trust allows co-trustees, e.g. spouse, children, hunting partners, to legally use and possess the firearms. Creates a clear legal chain of possession for estate planning, inheritance, or incapacitation of the original owner. Reduces the chance of accidental felony charges when transferring or loaning restricted weapons. 4. Estate planning and inheritance. When the settlor, creator of the trust dies or becomes incapacitated, the trust remains the legal owner of the firearms. A successor trustee takes control without the need to probate or transfer ownership through the ATF until distributed. This allows time to legally dispose of, transfer, or assign firearms without violating NFA regulations. Without a gun trust, heirs might unintentionally violate federal law simply by possessing the decedent's NFA firearms before receiving ATF approval for transfer. 5. Privacy and asset protection before ATF Rule 41F, effective July 13, 2016. Gun trusts provided a workaround for fingerprinting, background checks, and CLEO sign-off. Today, these requirements apply to all responsible persons of a trust. Still, trusts provide greater control, flexibility, and limited public exposure compared to individual ownership.